I'd also like to begin by acknowledging the traditional owners of the land that we're meeting on today, the Ngunnawal and Ngambri people, and to pay my respect to their elders past, present and emerging. And I'd also, before I leap into the substance, I'd like to acknowledge my co-author and collaborator and friend, Katrine Bewley, who is a former graduate of the law school, and those of you who've been around for a very long time might remember Katrine. Katrine sparked my interest in this topic, and we decided to, going on 2 years ago, decided to write something on this, and it's been a work in progress while we've all dealt with COVID and all of the disruptions that it has caused. Now, voluntary assisted dying in Australia, VAD, as it's known in shorthand, was, as I said, a project that I became interested in through these conversations with my friend Katrine in late 2019. When Victoria passed Australia's first voluntary assisted dying provision, that was almost 2 years ago now, that was passed and became operational later that year. Now, Western Australia has also passed, in the meantime, its own voluntary assisted dying law, and that law is now operational as of a few short weeks ago. Tasmania and South Australia have also passed VAD laws, though neither of those has become operational. And we're told that Queensland is very close to passing its own law. New South Wales is preoccupied with other things at the moment, but also debating actively the possibility of a voluntary assisted dying law. The Victorian law has become the model for all of those jurisdictions. It's a minimalist model, probably the most minimalist model passed anywhere in the world. Its eligibility criteria are very strict. So a person seeking to access a voluntary assisted dying process in Victoria has to present with a terminal illness. That illness has to be one that at least 2 doctors have certified to have brought that person to within 6 months of the end of their life, or 12 months in the case of people with a neurodegenerative condition. Those doctors also have to be able to attest that the person seeking the access to the VAD process is a person who is capable of and has made a voluntary autonomous decision to seek that process. And thirdly, the person has to be a Victorian resident, not necessarily of Brighton, but I'm trying to keep it as colourful as I can, given the difficulty of the subject matter in putting colourful slides together, I can tell you. So there's plenty of controversy in relation to the first 2 of those eligibility requirements, and there's been much written about that in Australia and around the world. But my focus, because I'm a constitutional lawyer, is going to be on the 3rd of those eligibility requirements, the exclusion of out-of-state residents. And the particulars of that are as follows. A person must, first of all, be an Australian resident and or permanent resident of Australia. They need to be ordinarily resident in Victoria, and I'm using Victoria here as the model because it's the jurisdiction that's been up and running for almost 2 years now, and it has also been closely modelled by the other states. So whenever I reference Victoria, you can take for granted that the other states' legislation is near identical, if not identical. And thirdly, and most controversially of all, a person seeking to access VAD in Victoria must, at the time they first initiate that process, they must have been a resident of Victoria for at least 12 months. Why is that the case? Well, it's a bit unclear. If you have a look at the debates in Parliament when the legislation was being discussed, it's clear that there was strong community support in Victoria for, and in Western Australia, I should say, for the residence requirement to involve a qualifying period. That came out of the community consultation processes that were conducted in both Western Australia and Victoria. The parliamentary debates also are riddled with references to the mischief of death tourism. That was a primary concern in Victoria and seems to have been a concern in the other jurisdictions insofar as there's discussion of rationales for the eligibility requirement. Now, the death tourism concern is one that very few people have been able to explain other than by reducing it to other underlying concerns. It's not a problem in and of itself unless you're in the business of just withholding access purely for the reason that you want to deprive people from other jurisdictions of the benefits of the law. So in the Victorian parliamentary debates, the 12-month rule was added between the passage in the first... It first went through the Legislative Assembly, the lower house, and in preparation for sending it to the Legislative Council, the upper house, the minister responsible decided to add this 12-month restriction. So then, of course, it had to be repassed in the lower house as well. It's not entirely clear why that was inserted other than as a sweetener for members of the Legislative Council who were perhaps more deeply concerned or vehemently opposed than had been the case in the Assembly. In Western Australia, the Parliament and the community was a bit more ambivalent about the 12-month idea. The expert panel that was advising the minister actually recommended against a 12-month qualifying period on a number of grounds, and they said if we must have a 12-month qualifying period, then there should be the provision for it should be possible for somebody to minister to waive that requirement on compassionate grounds in appropriate cases. But the bill passed without any such compassionate grounds waiver provision. The residential requirement in Victoria has already been litigated, but only on factual questions about people's movements, not on its legitimacy per se. That decision was one made in the Civil and Administrative Tribunal in Victoria, VCAT, and the tribunal member took a very relaxed view of residence. The Victorian Government didn't appeal either. So if you come and go from Victoria and you can demonstrate that your roots, so far as you have roots in any particular jurisdiction, are mostly in Victoria or have been in the past mostly in Victoria. The fellow who brought this claim to VCAT was someone who was quite itinerant in the years leading up to his terminal illness, but he had, for much of his life, lived in Victoria. So the tribunal member took that all into consideration and said, yes, for these purposes, we consider you a Victorian resident. So that's the VAD law. Now, let me tell you about Section 117 of the Australian Constitution, which has not been in the news, legal or otherwise, in Australia for quite some time. It looked like it might have been implicated in Clive Palmer's action against Western Australia, but for reasons of the particular configuration of plaintiffs and defendants in that case, Section 117 dropped out of that litigation. So it hasn't been litigated for almost 20 years now, probably at least 15. There's still an issue here, I should add, even if, just while I think of it, even if all states in Australia were to pass a law in these terms, there will still be people excluded. There's people in the territories and there's people who are new residents. So lest you look at the text of 117 and think that there's the territories are missing, you'd be right. This is where the constitutional lawyer's interest this problem resides. This provision was toothless for many decades in Australia. It only touched discrimination in form for most of the High Courts and the Federation of Australia's life. Any discrimination in substance, discrimination that was based on some proxy for state of residence, for instance, was unreachable through this supposed protection. That all changed in the late 1980s when the Mason Court adopted a substance approach to reading and applying Section 117, and it did that in the case of Street and Queensland Bar Association. It's a messy decision, though, even though it's still the leading authority on Section 117. There were 7 separate judgments, and all of the judges saw limitations in the reach of Section 117. In other words, they said it was not an absolute right, but they explained that quite differently. Some of the judges were very much focused on federalism and a federalism-based purposive reading of what the limitations might be. Others saw limits inherent in the legal concept of discrimination and wanted to make all of the limitations referable to that abstract question of whether or not there's a relevant difference between people who are treated differently or the same by a law. So we've got no clear test. Even though we know that this is to be applied as a matter of substance, there's still no crystallised formulation of how you would apply it. What we have tended to infer for teaching purposes and for mooting the possibility of litigation is a 2-part test along the lines of many Mason Court doctrines. First of all, a threshold question, if you like, of is there discrimination against an out-of-state resident in substance? And if the answer to that is yes, then a second question arises. Is the treatment of that out-of-state resident appropriate and adapted to a legitimate objective? So there's a prima facie rule against discrimination, but it can be defeated by a legitimate policy objective where there is appropriate degree of proportionality between the law and the objective. That was the 1980s, 1990s version of balancing in Australian constitutional law. You might say now it was a kind of a proportionality light. It was not a full-throated endorsement of international proportionality jurisprudence, but it was kind of getting at some of the same considerations in a more deferential to the democratic branch's way, perhaps. This High Court, the High Court that we have at the moment, 30 years later, headed by Chief Justice Kiefel, has embraced the international approach to proportionality reasoning and has, for about 5 years now, applied that in the context of other constitutional limitations. So, first of all, in the freedom of political communication context, and more recently this year in the Section 92 interstate trade context, and that was the outcome of the Palmer and WA litigation. Section 92 and Section 117 are very close relatives. They are both limitations on power with a federal structural purpose, and they both have to give way to well-tailored policy rationalisations. So it's very likely, I think, that the next Section 117 case, if it's any time soon, within the next few years at least, will install that structured proportionality test that mirrors the international approach in Section 117. And Section 117 would then look like this. You'd have the threshold question still there. Do you have a law which discriminates on the basis of state residence, either in form or in practical effect? And if yes, you move to the second stage, and this is where the international standardised approach to proportionality would slot in. First of all, you have to show that the policy objective is legitimate. If you can show that, then there's a question of whether that restriction, the discriminatory restriction, is a proportionate response to that legitimate policy consideration. And as with the international standard, the Australian High Court is now saying that proportionality is a function of three things that are addressed in a particular order. First of all, a question of suitability, then a question of necessity, and then finally, sometimes, in fairly rare instances actually, a question of what is sometimes called proportionality stricto sensu, or adequacy in the balance. Proportionality, strictly speaking. What I want to do now is run that test across the Victorian VAD restriction on out-of-state residents and see what the evidence is, pointing one way or the other, see what the sticking points are, and finally run with a prediction. Now, the first question's easy in the context of Victoria's VAD law and all of the other states that have modelled their new laws on Victoria. Yes, there is most definitely a discrimination in form. It's out in the open that residents of other jurisdictions are not welcome to take advantage of this provision, this treatment. So that's straightforward. The second question is much trickier. As to the initial issue of a legitimate policy objective, the High Court has said that this can be anything at all other than the intentional singling out of people in the discriminated category for no reason other than that you just don't like them. Right, so it's a very relaxed standard. Pretty much anything other than bare prejudice will count as a legitimate policy objective. And there were a couple of legitimate policy objectives, or potential legitimate policy objectives, that came up in the parliamentary debates in Victoria and have been mirrored in other jurisdictions. First of all, there's the therapeutic relationship. The idea being that to ensure that people who access VAD are doing so within the protection of a therapeutic relationship with their doctors, we need to exclude people from outside the state. The second thing that was raised as a justification was the death tourism thing, and I said that I wasn't convinced that that means anything in and of itself. That does reduce, though, to a couple of other potential considerations. I think it's really got to be about the financial cost of the provision and or the burden that the provision would place on providers of the necessary components of a VAD service. So there's three possible objectives. So I've ruled out death tourism and replaced it with two things that I think lie behind death tourism: therapeutic relationship then, and costs in terms of monetary costs, and the potential for the people who provide VAD to be overrun with excess demand if you were to allow outsiders in. Is the 12-month residency requirement proportionate to any of those potential objectives? There's plenty of things to throw on the scales, and just while I talk through this, I'll put that up so you can think along with me. These are the three stages that the Kiefel Court has set out for its proportionality balancing test, and they mirror what is used internationally. Now, in terms of the therapeutic relationship, to start, as I said, the rationale there is that voluntary assisted dying is a procedure that is too serious to entrust to a new doctor-patient relationship. But that assumes that that assumes a link that may not exist in reality in many cases. So the reality is in Victoria that plenty of people who avail themselves of the VAD process are doing so with doctors who are not their regular doctors. A very small proportion of doctors in Victoria have done the training and signed up to be VAD advisors and providers. I think it's 2% of GPs and 13% of oncologists. So with only 2% of GPs willing to become involved in this, there's every chance that a given prospective patient's GP doesn't want to be involved. They pass their patients on to others. So there's plenty of new doctor-patient relationships that are giving rise to decisions being made under the VAD regime in Victoria. And the flip side is that there are plenty of patients outside Victoria who have a therapeutic relationship with a doctor in Victoria, not just people who live in border communities, but also people who travel from smaller states, particularly to seek the specialist advice of a doctor who is, especially in relation to neurodegenerative diseases. There's only a couple of people in Australia who are considered to be experts in certain niche areas, and people will travel from all over Australia to see those doctors. Now, so the reality is that the therapeutic relationship does not map neatly onto residents or non-residents in a state. So that goes to suitability. As to necessity, you can probably imagine there's a sensible, easy alternative, which is to connect eligibility directly to the therapeutic relationship and cut out the proxy of state residents. If what you're really after is strong therapeutic relationships, then you don't need to talk about states at all. You just attach the eligibility to the therapeutic relationship, and that's what's done in Belgium and the Netherlands and perhaps in other jurisdictions too. Now, the second of the potential rationales that I floated, nesting under the death tourism smokescreen, is financial cost. The idea here being that states fully fund VAD consultations. It's not something that Medicare will reimburse in any measure. The Commonwealth has said we're not interested in participating here. So the consultations, the assessments, the lethal medication are all funded out of state consolidated revenue. And you might say it's reasonable then that the state's taxpayers be the beneficiaries of that expenditure. A couple of judges in Street toyed with this in relation to welfare benefits. You might argue, on the other hand, that healthcare is a special type of welfare benefit, and the fact that any of us can walk into an emergency department anywhere in Australia or call an ambulance anywhere in Australia and no one's going to ask what state or territory we're resident in, it's special and different, and it's by agreement that the component governments in the Federation make it available to all comers. You might say that it's different and special. So, in any case, at the suitability stage, which is a pretty low threshold in Australia, the High Court doesn't ask much of governments in establishing this suitability part of a proportionality justification. It's probably easy enough for a government to say that excluding outsiders is a suitable way of confining the benefits of a program to people who have paid for it. But you'll guess now what I'm going to say at the necessity stage, which is that there's an obvious fix here. There's an obvious compelling alternative policy that you could put in place, which is to institute a cost recovery measure against people wanting to come in from outside the state and access. It wouldn't be that difficult, I suspect, based on what I have read, to quantify roughly the cost from start to finish of providing this suite of services and advice to people. Interestingly, you would actually then discriminate against out-of-state residents in a new way. You'd be charging them for something that you don't charge locals for, but it would be a lot easier to defend that discrimination, provided there was no revenue raising, provided it was just direct cost recovery. Then a state wouldn't have a problem, and indeed states do that all the time. Now, the third and final of the potential policy rationales that I floated was the burden on providers. Most people who fit the eligibility requirements in Victoria are very sick, and they need home-based assessments. And most of them elect to take their lethal medication, if they do, at home as well. So there's a lot of travel for the doctors, and there's a lot of paperwork. There are a group of social workers who are employed by Vic Health called Voluntary Assisted Dying Care Navigators, and they do a lot of travel as well, and they advise and support families in particular. As you'd expect, doctors are not forced to participate in this scheme. It's an opt-in scheme. So we have, I think I mentioned already, in Victoria, so far 2% of GPs have done the training and opted in, and the training's not onerous, it's only a few hours of online training. So there's very few GPs who are at the moment prepared to be involved. 13% of oncologists so far, and a similar proportion of neurodegenerative expert doctors. Cameron McLaren is a person who has become synonymous with the VAD law in Victoria. He's a geriatric oncologist in Melbourne, and he has single-handedly consulted and assisted close to half of the people who have followed all the way through with this process in Victoria so far. So that's the kind of burden that we're talking about. If you were to flood the system with new potential clients or patients, then people like Cameron McLaren might be stretched beyond the capabilities of one person. So is an exclusion of out-of-state residents a suitable way of reducing the burden on providers? Yes, it probably is. It seems rational enough. Is it necessary? That is less clear, and if you compare the Victorian approach with the approaches in other potentially comparable jurisdictions, and the USA is particularly helpful here because there's a small handful of states in the USA that allow VAD, and none of them have a 12-month residency requirement. Most of them have a residency requirement, but none of them attach the qualifying period. And there's nothing to suggest that they have been inundated with large numbers of people coming from outside. A few, yes, but not large numbers. Dignitas in Switzerland, who have over many years accepted Australians for their private voluntary assisted dying service, they say that 1 to 5 Australians per year have been accessing their service. So there's not a large number of people who are motivated to travel significant distances in Australia to undertake this care. And in Victoria, there are a number of other contentious medical procedures that are provided to people from out of state. No questions asked. So Victoria is the only jurisdiction in Australia, I think, still to offer late-term abortions, and they provide that to anybody from any part of Australia. And in fact, they fly doctors in from other parts of Australia to meet their peak demands. They also, in Victoria and in many other states, allow IVF treatment to people who don't live in the state, but who want to do that in Victoria for some reason. So it's a preemptive. The 12-month residency requirement is a preemptive strike against a problem that may not eventuate. I better wrap up now. I was going to talk a bit about the legal distinction that I see between out-of-state residents per se and people who are new residents in the state, people who have moved to Victoria or Western Australia but have yet to reach their 12-month qualifying period. I can talk about that in the question time if people want. What do I think a court would say? Look, in short, I think that in the case of a new resident, someone who had moved to Victoria but had not been there for 12 months yet, I think they have a very strong case under Section 117. Possibly weaker, though, for someone who was resident in another state, not willing to move to Victoria, wanted to access from their other state. For the reason that there are some federalism considerations that might be raised by the states to defend their decision to exclude, that don't apply for the new resident context. So I'll stop there. I've had one question come in by email from someone who needs to go shortly, so I'll run with that first and then I'll invite questions from anyone else. So Gregor sent me a question by email and said he had to disappear to teach before our hour was done. So I have thought about your question, Gregor, and I'll read it out to everyone. How do the voluntary assisted dying provisions in the 4 states that have introduced them ensure that they are not making lawful any communications which, if taking place online, might contravene subdivision G, offences relating to the use of carriage service for suicide-related material in the telecommunications services of the Criminal Code, Commonwealth? I would have had no idea about that, but for the fact that my co-author, Katrine, has thought about that and has actually written an article which is coming out with a bunch of colleagues from QUT, where she works, which is coming out in the Monash Law Review, and I'll find you the citation and send it to you. But the answer is actually the answer is very pragmatic, and that is that in Victoria, the Health Department has issued doctors with guidelines to insist that they not talk about this over the phone or on Zoom. So Cameron McLaren has apparently driven out of Melbourne to various places to visit people. I'm not sure how it would go in Western Australia if you have someone in up in the Pilbara who wants to speak to an oncologist or a neurologist, but in any case, that's how Victoria got around it. Everything is face to face.
Isn't there like a ministerial decision involved in authorising the process in some way, and that's a VAD communication? Is that not permitted to be done by email? Does that have to be done by carrier pigeon?
Well, you could do it on your desk, couldn't you? Do it in an in-tray with a stamp.
Right.
I think I have read Katrine's article on this, and I think that they did suggest that's a possibility, but that it's much less vulnerable than the actual. It's much more removed from the advice about suicide, because the Commonwealth provision is about preventing people talking about suicide.
It's about inciting or instructing in the means of suicide.
So that's probably doctors. Yeah, that's probably going to be doctors and some minister or ministerial delegate who is involved in the stamping afterwards, after the patient has made their decision. Probably is more removed from the providing advice and inciting suicide. Yeah, I think that was where they got.
That's not the answer I was expecting. That, whatever was done under VAD, under legislation, simply cannot be characterised as instructing in the methods of inciting, rather than what they would see as pragmatic.
Yeah, well, better to be safe than sorry. Yeah.
Through not using a carriage service.
Better to be safe than sorry, and easier for Victoria to do that than So and look, maybe if you desperately needed the services of someone who was in Melbourne and had an hour to spare and they couldn't travel to Bairnsdale or Mildura, maybe if they gave medical advice to a doctor who wasn't interested in personally taking advantage. And then that person, face-to-face, turned around to the patient and said, I believe, possibly. I mean, it's a fudge, but I think I think Katrine's article in the Monash Law Review concluded that the real danger zone is the doctor and the patient on Zoom together, and then if you can separate them out, then there would be less and less risk. But all the better if the Commonwealth were to issue some clarification to say VAD is not what we contemplated. Not sure that this government will, but perhaps in future.
Surely
Yeah.
it's a prosecutorial discretion as well. I mean, you can have this open public interest if it's legal to do it face to face.
Sure, but it sets up a constitutional problem, doesn't it, of potentially the Victorian legislation authorising conduct that might fall foul of a criminal prohibition in the Commonwealth.
Yeah.
Code, so there's that aspect of it.
Yeah. And the prosecutorial discretion in some other jurisdictions has been exercised in unpredictable ways, apparently. Yeah.
Well, look at that for everything.
Yeah. And even in this context, in some other places, I've read about some cases in the UK where people had been advised that if they assisted their partner to consume lethal medication, that it was highly unlikely that they would be prosecuted, and yet, lo and behold, a different person has made the decision. That DPP has retired, and someone new has decided. Hang on, okay, plenty of scope for more questions. Pleasure. I'll send you the reference.
Just on that, of course, the Commonwealth also has jurisdiction with regard to postal communications, so they could expand those provisions that currently relate to a carriage service to include postal communications. And they've done that for menacing, harassing and causing offence, which came up in the Mona's case. Him posting letters. So, there's a lot of scope.
Now that we've got 4 states have passed VAD laws, they might decide that actually they don't want to come out swinging against this class of medical activity. Yeah. Molly.
I have a very ignorant question about how many people take advantage of these VAD laws. I mean, I know some states aren't active yet, but if they were active, is it 4 or 5 a year, or is it 20 a year?
No, I could dig around in the paper and find the exact numbers, but my recollection is that in Victoria, I think in the first 6... So in Victoria, the legislation requires the overseeing board to report every 6 months. And in the first 6 months, I think there were 50 approvals and 50 people were issued with lethal medication, but only half of them consumed that medication. Some of them would have changed their mind, some of them would have died before they made that choice. Yeah.
It was my experience when I worked as a law clerk in the US. We had a patient who wanted to die, and the law didn't allow him to die at that time, the law in the state of Georgia. So he got a special decision of the Georgia Supreme Court to allow him to discontinue his medical treatment, which would have killed him right up, like within 2 days. And once that decision was in place, he said, never mind, I'll go on. And so the 50% not availing themselves of it is not surprising.
Yeah, I can fully relate to wanting to have that available should I choose to do that, but not wanting to say today's the day. Yeah,
Right.
Absolutely. Yeah.
If other states bring this into operation, the argument about death tourism overburdening the ones in Victoria presumably is going to become weaker and weaker.
That's right, yeah. So they'd have to come up with another rationale.
Except for the territories.
Yes.
Except for the territories. Well, the territories are only... Yeah, the territories, the only thing stopping the territories from having euthanasia laws is the Commonwealth Government. So it's... But because they are...
We're doing that Queanbeyan in Canberra then once it comes through New South Wales.
Yeah, that's right. Property prices in Queanbeyan. Yeah. I think a Commonwealth Government that saw that a majority of people in the 6 states, let's say so Queensland's almost in the bag with this. New South Wales is, as I say, fighting more important fights now. But this was something that was coming on in New South Wales earlier this year, and we had expected that we would see this unfold this year. So eventually, when they recover from their year, presumably this will come back on, and maybe even the fact that a lot of people have gone through some of the traumatic experiences that people are having with coronavirus in New South Wales at the moment, maybe that will even change the calculus a little bit as to who's pro and who's anti. But the experience in Europe has been that the more people sort of look around and see other jurisdictions doing this, the more... the less bothered they are by their concerns about sticking their neck out. So Spain has recently passed, Catholic country, has recently passed a VAD law because they've watched what's happened in the much less conservative Northern European countries and seen that the sky has not fallen in and the numbers aren't through the roof, and have been reassured by that. So I would expect that if eventually, even if New South Wales for some reason steps out of this, if you've got 5 states saying that our community is comfortable with this, then I can't imagine a Commonwealth Government holding out for that much longer.
There's some Northern Territory experience of this when they had its euthanasia laws before they were invalidated, and there was reportedly some movement of people into the territory.
There was, yeah, actually. Max Bell was the very first person to avail themselves of VAD law in Australia. He was a taxi driver in Broken Hill, and he drove to the Northern Territory to access the Northern Territory's VAD in the couple of weeks where it was operational before the Commonwealth closed it down. Yeah. So people in the territories would find ways that, and hopefully the Commonwealth wouldn't take too long to read the tea leaves and actually reopen that. Yeah.
Doesn't the Self-Government Act here actually preclude the Assembly from passing?
It does, yeah.
So we still have to go through Parliament to start with.
Oh yeah, that's right. Yeah, but so that's right. It would have to be a conscious act by the Commonwealth to allow that. But if that became a populist act, then I don't know why they wouldn't do it.
What do they have to? What evidence do they need to prove 12 months?
Oh, it's the standard things: driver's licences and rates bills and everything. So that hasn't been. The 12-month aspect of this has not, to the best of my knowledge, been tested in Victoria. People have only been arguing about the broader requirement of are you a Victorian resident, and the people and the new person has not had to make the request. But if you, I don't know, I suppose if you bought an apartment in Melbourne now, and then 2 weeks before you have your first appointment with a VAD doctor, you moved into it, I reckon. Well, look, there's every chance that no one would ask any questions. I think.
Canberrans have got a place down on the coast.
Yeah. Which coast? Yeah. Well, this is the thing. I mean, it doesn't really differ from residence tests for other for other purposes. And there aren't that many residence tests in state law these days. It tends to be things like gun licences and, noxious chemicals. And
Different way of doing it. But
yeah. That was Professor Stephen Bottomley, by the way. So I think, the conversations I've had with people who are involved in administering the Victorian scheme, I've had a couple of chats with the folks, the social workers who run the advisory service out of the hospital, the VAD care navigators, and they reckon that the Victorian Government is not going to. The Victorian Government is not particularly interested in holding a hard line on this. No. Well, so in order to get it through Parliament, they needed to make concessions to people who are not going to be actively now checking all of the public records to see how long you've lived in your flat in Richmond for. So it's more. It's more what would happen in other jurisdictions where perhaps they took that more seriously. So Victoria, yeah, and it's a shame that it has to be. If nobody within government is particularly committed to the rule, it's a shame that it has to be there. But I guess for them, as the first jurisdiction, that was the price of. So they might actually quite like someone to challenge it. I got a couple of calls from people who were.
It was political, so. It was introduced so that no other state could go stop killing our citizens, and so that other states or opponents in other states could go, well, you could just go to Victoria if you want to do that. We don't need to legislate here.
I think that's right. There's a lot to that, and in fact, that's one of the things that I was going to raise if I'd taken my detour through the federalism considerations. I think there's a good argument that keeping, and this was going to be the state's best defence against a challenge here, was to say that we are doing other states a favour, not individuals within those states, but other states as a polity. We're doing them a favour by not letting them free ride on our initiative here. If they are not prepared to have the hard conversations to deal with this for their own people, then they should not be able to take the easy way out and just export their problem to our jurisdiction. Yeah, so that is a I think pretty persuasive federalism-based reason for saying that in Australia at least that a bare residency requirement would pass muster. But the qualifying period I don't think you can justify in that way.
Yeah, can I ask a question on that basis? Because I think that's like maybe so the last element of the proportionality test, like the strict sense proportionality. I mean, that's really where the waiting period comes in. So is that also part of your analysis? Because that, say, 12 months might actually be excessive relative to that policy goal, which is actually probably the weakest point of the proportionality test. So it's like, why 12 months? Because it seems like an excessive amount of time. Yeah. It could have been just as easily half that, kind of would have achieved its goal, kind of a thing.
That's right, yeah. Australian courts are dead scared of that third element of structured proportionality. They'd much rather deal with it earlier on, and they might work it in at necessity by saying we can't see any, or at least begin the discussion at necessity by saying we can't see any other jurisdiction dealing with this in this way, imposing the qualifying period. So we're not convinced that it's necessary. But you could, if you in other courts where they're less paranoid about the separation of powers implications of that balancing, that might be a more logical place to do it. Yeah, Matthew.
This the temporal issue. Sorry if you covered this and I missed it. So we have the 12-month residency requirement. I know the CAD have been flexible about what residency means and authenticity and nexus, whatever it might be. But you said when you started that there's a requirement that two doctors sign off and say you're going to die within 6 months. Would the High Court be looking at that particular calculus and saying, okay, well, this thereby... invariably excludes anyone who might be interested in taking advantage of this because they've just recently been diagnosed with an illness that might be covered by the...
Oh, look, I mean, in a polity, in a constitutional system where you had rights in the constitution that were about individuals and concerned with individuals for their own sake, yes, absolutely. But in ours, where our rights are just a way of brokering good behaviour amongst the polities in the system, I can't imagine they would allow that on their docket, really, because that's a kind of fundamental question about your right to life and your right to choose death and your right to choose or refuse healthcare, and we just don't have anything of that sort. So someone could raise that, but then there are precedents for that overseas. So even if they wanted to duck the human rights question at the heart of that, they'd be able to say, we're not in a position to say that this is ludicrous because other jurisdictions have settled on 6 months. And I think 6 months is at the most stringent conservative end of the global spectrum of what these doctors have to say. So Australia's laws are, well, the Victorian model is said to be, and I heard this before Spain, so I haven't read the detail of Spain, but at least before Spain, Victoria was the hardest to access VAD regime in the world. So yes, doctors would take issue with the with 6 months as opposed to 5, as opposed to 7. But in terms of proportionality, and with a focus on federalism, the High Court's bound to say, we defer. We're not experts. We're not in a position to know what's medically optimal here, or how the balance between the different views in society and the expense incurred by the healthcare system and all the rest of it. It's not our balancing. It's not our balancing to do. Yeah.
I wanted to share something from India. I'm from India. Great talk, Professor Simpson. That was very good.
Thank you.
A lot. Deva, I'm from India, and voluntary assisted dying was the talk of the town in India 3 or 4 years back. I think 5 to 6 years back. I don't know how many of you have heard about Aruna Shanbhog judgment of the Indian Supreme Court. Basically, Aruna Shanbhog was a nurse, and she got strangulated by one of her assistants, and that strangulation cut off the flow of blood in her brain, and she was in a vegetative state for 20 years. And obviously, her lawyers filed a petition in the court, for voluntary assisted dying. She was cut off from the family. She was engaged pre-accident. She was engaged. Obviously, her fiance, got married to someone else because she couldn't move or. Anyway, so the case went to the Supreme Court, and the Supreme Court made this distinction between active euthanasia and passive euthanasia. So active euthanasia is where you give the death medicine directly, which is illegal in India. You're not allowed to do that. And passive euthanasia is where you withdraw the medications that is necessary to keep that person alive. So yeah, she was allowed to be passively euthanized. And yeah, she died, I think, 6 months after 6 months, 6 to 7 months after, her other medications were withdrawn. She died after a struggle for, after 20 years of being in a vegetative state.
Yeah.
It's a very confronting judgment. I mean, I read it when I was only 17, and it had a very bad effect.
They do that everywhere. I mean, that's just drawing of care. I mean, they obviously do keep people in vegetative states alive for a long time, but there's been cases in America, cases
That was one of the things I wanted to comment on about the low level of engagement by doctors in this. And that whole, we all know there's a series of clinical decisions that get made about death all the time. And I just wondered whether doctors are sort of voting a little bit with their feet in Victoria because of the low buy-in. And I wonder, if you've got any sense about what doctors think about these legal tools for something that's a highly complex clinical set of decisions.
Yeah. Well, I haven't spoken to any of them, any Victorian doctors about this myself, but I have spoken to the care navigators, the social workers who work with them. And they've said that there's been a lot of kind of hanging back and watching, and that their expectation is that number will gradually creep up, but still not to the point where you've got even a significant minority of doctors prepared to engage in this. And I don't know really whether that is because they're making a personal conscientious objection, or whether it's more pragmatic and it's that they don't particularly want to encourage a practice in these kinds of patients, or I don't know what the professional career implications would be for a person who sort of put their shingle, who allowed it to become known that they were agreeing to talk to patients about it's possible that it would completely change the complexion of your practice, or that people might be worried about that. Yeah, but the expectation is that it will creep up. Yeah. I'll keep you posted.
Most doctors, I think, nowadays would support it, and I think most doctors that would be asked to be involved are generally GPs, because people go to their GPs unless they're under the care of an oncologist. And I've just written a thing about the low uptake of the training for doctors to prescribe step 2, early abortion, less than 9 weeks, mifepristone. And only about 10% of GPs have done the training. It's 2 hours, you can do it online. And 90% of GPs are not conscientious objectors to abortion, right? They don't do it because they haven't got time, or they've got reasonable but lame excuse like that, or because they think that they will be stigmatised and they'll be seeing abortion people left, right, and centre. And that's a particular concern out in the sticks, because everybody knows everybody's business, right? And of course, you can just access it telemedicine via steps, but it's a bad excuse, I think. So yeah, give them a couple of years and I'll write another paper like that one. So, get on with it.
Yeah. Great, thank you. Time?
Yeah.
Okay. Thank you, everyone.